Last week, Triller, the company behind the Jake Paul and Ben Askren fight, filed a lawsuit against several different websites and H3H3 Productions. This was what we would call like a legal rope-a-dope. The lawsuit is entirely frivolous and has no merit to it, but the intent of the lawsuit was to scare other people who may have illegally streamed this broadcast and get them to go to Triller's website, where they could pay $50 to be released from the lawsuit they weren't even included in. This was a cash grab of sorts, where they tried to get people to pay them $50 for a stream they may have stolen. But also, the problem with that is they're putting down their name, their address, their contact information, and then they're telling Triller, they're admitting to illegal activity. They're incriminating themselves to a federal crime. And while the likelihood of prosecution is low, whenever you have an admission to a crime, especially on some sort of, documented website or form or something like that, your chances of prosecution go way up. This was entirely intended to get people to that website. Triller wasn't serious about the lawsuit at all. And we know they weren't serious because I told you in the video last week what was wrong with the lawsuit. And that was that there wasn't a single fact alleged in it that would lead to the ability for a court to even hear the case, much less to prove the defendants guilty. So, what's happened since then? Well, all but one of the defendants have been dropped. And now the case is looking more and more like the stinker I said it was. Let's talk about it, and then let's ultimately get to the point of what's going to happen to H3H3. Are they liable? We'll talk about all of that as we get through this video. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, go ahead, hit that like button, subscribe, hit the notification bell. Don't miss any more videos. All of those things really, really help the channel. So thank you very much for that. All right. So this lawsuit was junk, and I pointed this out last week, and I've got links to the video up in the corner up here. There's a little eye that you can click on for a link directly to that video. And at the end of this video, there will be a card that you can click right onto it if you want to go watch it there. Either way, make sure you check it out, and you can see all of the problems with this lawsuit. But it boils down to the part where they failed to include a single factual allegation. Now, believe me, I have read your comments. I have heard comments from other people online. I've seen all of it about how H3H3 admitted to doing this. He admitted to pirating the broadcast and restreaming it on his own channel or whatever. That's fine. That may end up being a big problem for H3H3. Right now, none of that was ever included in the lawsuit, and it doesn't matter how much you say on the internet if the plaintiff isn't going to include what you said on the internet in the lawsuit. And to show you how unserious the plaintiff was, this is something that apparently maybe even millions of people have seen, H3H3's admission to piracy. And still, neither Triller nor their lawyers thought it wise to include this essential fact in the complaint at all. In fact, they didn't include anything that would show a judge that any of the defendants even streamed it. None of it. They just alleged that they could stream it and did, but they didn't have a date, they didn't have a link, they didn't have a screenshot, they didn't have a quote from H3H3. They had nothing to support their legal conclusion that this was illegally done. And that is a huge problem in federal pleadings. You have to plead a fact that will allow the judge, at least one, that will allow the judge to go ahead and hear the case out, because you have to plead fact questions, basically, that the defendants can respond to. And if you don't do that, you're not going to get past go. And this lawsuit is basically dead in the water. Now, all except for one party has been dropped from this case, and no, that party is not H3H3. It is the first name party, because that is the rule. This is something called Misjoinder, right? In federal lawsuits, when you're bringing the same claims against multiple parties, you have to have some reasonable nexus of activity between those parties to make them a joinder to the claim. You have to have a similar set of facts for each party, and some of those facts need to overlap. Again, they didn't allege any facts in this complaint, only conclusions. And since they didn't do that, they didn't have the facts to support it. So the judge, prior to this lawsuit being even served on a single party, just went ahead and removed everybody from it and said, you've not shown anywhere that there is a joinder of parties in this case. So this is misjoinder. So if you want to bring the lawsuit against these other people, you have to bring individual lawsuits against all of them, or you have to do some research and show how they're actually related and then tell the court about it. Critical step in knowing something was done wrong is telling the court that it was done wrong and how. It's only the first thing you learn in law school. It's the most important part of a lawsuit, is telling the court how factually something happened, and they didn't do it. And the reason, in my opinion, that they didn't do it is because they know it's frivolous and they knew it was going to get dismissed. But if they could just pay for some introductory work, they could maybe out-earn that on scaring people into paying this $50 fee to them. The problem is, if they were to take this case all the way through the court system, the remedy is up to $150,000 per event. They're not going to get $150,000 per event. They're likely going to get some multiple of $50 against any individual user and some multiple of whatever their licensing fee is against users who took it and restreamed it. And believe me, that's a lot lower than $150,000 for most people who would be licensing it. When you think of licensure, think of like a bar, like a Buffalo Wild Wings or something, and you go in and you can watch the pay-per-view fights. Buffalo Wild Wings pays for the privilege to rebroadcast that in all of its locations, and based on the estimated amount of attendees, they'll go ahead and have a licensing fee agreement with the base company. And so they would get some multiple of that. And it's not going to be very big for most of these streamers or most of these websites that would be rebroadcasting it. They would have to prove out what the license fee is, and that would be the multiple. It's up to $150,000, but there is no guarantee. In fact, it's extremely unlikely that you're going to get that from someone even restreaming to several other people this fight. It's just not going to happen. So with that said, they know that the costs of this lawsuit are going to far exceed the remedy. Or could. I shouldn't say they will, but they have the potential to far exceed any remedy that they're going to get. And even if they get judgments against some of these people and companies, if they're judgment proof, as in they don't have any money, they're not going to get any money out of them. And going after them for collection is going to cost them more and more and more. The idea is entirely geared towards getting these people to their stupid website to admit to illegal activity and give them $50. And that's why H3H3, as much as people think that that guy's a scumbag, and I don't like that guy, I don't care about him, I have no interest in H3H3. Even if he did all of the things and admitted it, if they're not willing to put it into the lawsuit, that's their own fault, and he's going to be fine as long as they don't do that. And some YouTubers out there have suggested that this sort of conclusion that I'm talking about today is some sort of surprise or is a weird sort of thing or came out of nowhere. No, this was perfectly expected. If you just looked at the lawsuit at all, there was no case here because they didn't write it down on the paper. If you have a case, you gotta put it on the paper when you file it with the court. They didn't do it, and in my opinion, it's because they're completely unserious about the underlying legal case at all. They're just trying to grab those 50s where they can from anybody who might have jumped on and clicked on a video on YouTube. And that's not the proper way to do this. This is not the proper use of the legal system, and they seem like a pretty terrible, well, I don't know if they're a bad company, but they've made a terrible strategic decision here. And I personally hope it impacts them because I hate when people abuse the legal system like that. But anyway, there you go. Drop a comment down below. Tell me what you think about it. If you watched my other video, you knew this was coming. We'll see if it develops, if they refile against other parties. I'm guessing they won't because their complaint as it stands is still defective against the remaining defendant, which is Film Daily. And until they decide to put something on paper, they got nothing. All right, until next time, guys, peace. Peace.